Mrs. Jensen, you recall having a conversation with Mark Jensen concerning your prior sexual history, correct?
Yes.
And it's now your testimony that you don't remember when that conversation occurred.
I know we had the conversation in the time frame I said earlier, which was in 1999 or 2000, somewhere in there. I don't recall anything prior to that. Yes.
Well, didn't you just testify earlier that you don't recall that it could have occurred in 1998?
I don't recall that any other conversation occurred, yes. Or that's what I meant to testify.
So you meant to testify before the break that the conversation could not have occurred in 1998?
No, I did not say that, but there was a conversation in 1999 or 2000, that I know for sure. There may have been one in 1998, I don't remember.
Okay. So you're saying there may have been a conversation in 1998 between you and Mark Jensen where you described each of your previous lovers?
There may have been.
It's marked 146, but I'm not sure where it is right now, so I'll keep looking for it.
Your Honor, do you have exhibit 146 up there on your desk? We're looking for...
There is an exhibit here. What is it?
No,
Doesn't have a number.
that's not it.
I don't think I have.
Exhibit 146? This
No.
No. And you have exhibit 146? Is the exhibit 146 more than described in this paper? In the interest of time, it's my understanding this document is exhibit 146. It just says, there's another one like this floating around, and I simply request this be marked as exhibit 146 so I can show the witness something.
Look, there's 146A.
146A.
I found it.
Oh, you found it? Yeah. Never mind. Now, Mrs. Jensen, I'm going to show you these documents and we'll go through them. This is Exhibit 146, and you recognize those names?
Yes.
Okay. And Exhibit 149, and you recognize these names?
Yes.
And Exhibit 150, and you recognize these names?
Yes.
And Exhibit 151, and you recognize that name?
Yes.
And Exhibit 152, and you recognize that name and the description of what's going on here?
Yes.
And Exhibit 153, do you recognize, just read through that and read it to yourself, you don't have to read it out loud.
Okay.
Have you finished reading that? Do you recognize what's described in there?
Yes.
In Exhibit 154, do you recognize the name and what's described here?
Yes.
You recognize that?
Yes.
And then you recognize the subject matter that's being discussed here? Exhibit 155?
All of it or just, all of it? Okay. Yes.
Exhibit 156, do you recognize the names there?
Yes.
And Exhibit 157? There are some names written there.
Yes,
Correct?
Yes.
And Exhibit 158, do you recognize the names there?
Yes.
In Exhibit 159, do you recognize the issues and the names that are being discussed that written there?
Yes.
Now, these are notes concerning conversation that you and Mark Jensen had,
Yes.
and it's your testimony you had this conversation on this subject matter on more than one occasion,
Yes.
and that the earliest time could have been sometime in 1998,
Possibly.
and you just don't remember when.
Right.
Now, well, let's start at the beginning. There's a whole list of names here, correct?
Yes.
And these are all people who've been previous lovers of yours, correct?
Correct.
And who is the, just so I can get this in order. So,
Are you going to do names?
yes,
Use first names if at all possible.
I will do that, if the first name is sufficient.
Although I do notice one of them is Bruce, but
Nobody in this courtroom, right?
No.
go ahead.
Okay. Now, who was the first lover that you ever had that you told Mark Jensen about? Using
okay,
first
go
name only.
I
want to get in order.
hadn't heard your whole question. Who is the first lover,
First lover.
about whom you told Mark Jensen? First name
First
only.
name only.
I don't know which one we talked about first.
Well, I'm not talking about which one you talked about first. I'm talking about which one was the first lover that you ever had that you talked to him about. In other words...
Well, I
you
don't
told Mr.
recall seeing that
Why don't
name
you
on
get-
that list. Can I see the list and I'll let you know which one? Thank you. All right. This would
Kevin?
be- Yeah. These are not in order, by the way.
I understand that, and we'll get to the second one in a
Yeah,
moment.
okay.
So it's your testimony that the first lover you'd ever had, whom you told Mark Jensen about, was Kevin?
It would appear so,
And-
at least on that list, yes.
And the note here says, Kevin, only anal she's ever done. Last time she did the on-top grind was smallish, couldn't stay in the grind. Fit the back, what does that say?
Where are you?
Right here?
I don't know.
You can't read what that says?
No,
So the first lover you'd had that you told Mark Jensen about was Kevin?
I guess so.
Well, let's see.
And Judge, I renew every objection I made at the break.
and I'm going to renew every ruling that I make.
What's this notation here about Darren 14 and then 18?
Well, I will say this, Mr. Gemways, you're asking her to read notes not of her creation, and I think what you need to do is approach the witness from the standpoint of the significance of the event of disclosure and why it would be memorable.
Well, Your Honor, I'm trying to do is make sure I've got it in the correct order, starting from the beginning.
Is the order really critically important?
Well, I could just go through it page by page, I suppose, but well, let's put it this way. Does this alter your perception at all of who the first lover was that you talked to Mark Jensen about?
Well, again, I don't technically say that Darren and I ever had sex. I think when I was about 18, I gave him a blowjob once, but
And he was 14?
no.
Well, it says Darren 14.
Yeah, we dated when I was 14.
And then it said, well, let's read what it says. Darren, 14, then the word after that is 18, the number after that's 18. We staying at her mom's, sleeping on the couch. She came home and blew him, process of figuring it out.
Let's do this. I'm going to, this is going to be the briefest of breaks in history. You're just going to go out and stay in the hall for a minute, and then you'll be right back. So you can't, not only can you not cough, you can't even take a breath of air. Look, and I don't want to make this long. This is going to, number one, it's going to take forever. Number two, I think it's unnecessarily embarrassing to the witness, regardless of the circumstances here. Number three, there are notes not of her creation, although certainly I'm not saying you can't get into some of the extensive detail that's put in there, because it had to have come, I suppose, from her into the source which recorded, to the source which recorded it. But the point is not for her to recount the whole history, but just to point, I think your purpose, if I'm not mistaken, is to point out how peculiar this is, that someone would be asked to give this kind of a recounting, and that someone else would write it down, and let's just get to that and do it as rapidly as possible. And
Your Honor, it's not as though I enjoy wallowing in this.
I didn't say you did.
The fact is, when I asked her to direct me to the first lover she made reference to, she directed me to Kevin. But then there's these notations regarding a guy named Darren, she's, according to this, 14. The numbers 14 appears after Darren, and then 18. And now she's recounting that when she was 18 years old, she performed fellatio upon him, and the inference that I draw from that note is that he was 14 at the time.
What's the significance of that? The significance of this is, what's peculiar about this is not that a woman would tell a man that she had sexual relations with someone when she was 14. The significance is the really peculiar, or okay, vice versa, the peculiar nature of this, and the reason it's being admitted is just the fact that someone would be questioning her about this and recording this. And I understand that the details do suggest that the examination by the accused would have been very, very thorough, and that's what makes it peculiar. But I don't want to go through her whole sexual history, and I don't want to take all day.
I don't either, Judge. And I guess I'll just go through some of the high points with her then. Is that what you're proposing?
No, my point is to point out that which makes it peculiar.
Well, I thought I was doing that. But
Well, you were doing it slowly. Ask the jury to come back
Wait,
in.
this is outrageous. This is absolutely outrageous.
You made your objection, I overruled, I don't want to hear any more. If you have more of an objection,
I do.
Different objection, fine. And I certainly think it's an error for me, I don't want to say error, that's the wrong word, for a judge. I think I should give an instruction.
not in the absence.
I'm not going to do it if he doesn't request it, but I think there should be one given.
I don't. I mean, that's my, maybe I craft one later or look at it, but right.
All right,
the one,
all right, you've made yourself clear. Now state what further objection you have.
rape shield law.
Well, with respect to, no, she said she was 18?
She said she was 18 and then.
She was 18. Where's the rape
I did
shield?
not say that, you did.
Yeah.
Okay, here's,
And
she said they started dating when they were 14.
Pardon me?
She said they started dating when they were 14.
Well, look, get into, you can get through this without getting into all this.
Your Honor, she said the first guy was Kevin, and now I'm asking her if the first guy was Darren. I'll ask her that and move on.
Judge, and that's where I was saying this is outrageous. When he suggests that she's having sex with a 14-year-old, I mean, this is unbelievably prejudicial, I think. But the rape shield law, I think we have protections against essentially examining women to try to point out, to try to convey that the examining party thinks they're sleazy.
He's
basically.
not trying to prove that she's sleazy. She's trying to prove that the defendant is sleazy.
Trying to prove that she's not telling the truth.
All right, yeah, I understand that, and that she was suborned. So let's get on to that. Bring the jury in.
Please be seated.
Now, Mrs. Jensen, was Darren before Kevin or after Kevin?
I think I had oral sex with Darren before I had sexual intercourse with Kevin.
Now, and I'm going to go through this one page at a time, and I'll just mention the first names. And this isn't just in the order that they appear. Starting with Exhibit 146, there's a person named Mark. You indicate, or it's indicated here, seen him 3 times. Correct? Correct? Well, did you see a person? Did you see a person named Mark, military boy, 3 times? Directing your attention to Exhibit 146, now you see the person's full name? Mm-hmm. Is that a name that you gave to Mark Jensen?
Yes.
And is that a person you previously had sexual relations with?
No.
Wrote, has seen him 3
Okay,
times.
yes, we had sexual relations. I don't consider him one of the list of that I had sex with. We had oral sex. But yes, that would be sexual relations under, yes.
And then the next person, and you describe in detail what you did with him, correct?
Yes.
Or it is the description
It's,
here.
yeah, the description is.
And then there's a name, Jack, correct?
Yes.
Manager meeting, St. Louis. And that is one name we need to go into. That's John Jack Joseph, correct?
Yes.
A person that you described to Mark Jensen.
Yes.
And then there's another name, Mark, correct?
Yes.
Musician, went up to something or other, stayed in his room, correct?
Yes.
And then there's Brett, at a bar playing pool, correct?
Yes.
And you told Mr. Jensen that you liked his butt.
Yes.
That he was hesitant, you made it happen.
Right.
Then there's a person named Tracy, Pittsburgh, met in St. Louis at a bar, correct?
Yes.
Then there's a person named Steve, correct?
Yes.
And in each of these instances, you provided your husband, Mr. Jensen, with specific details as to what you did with each one of these persons, correct?
Yes.
And then there's a person named Bruce, 2 nights and a morning, correct?
Yes.
And then there's listing Thursday, Friday, Saturday, and Sunday, correct?
Yes.
Then there's a guy named Joe, a one-nighter, correct?
Yes.
Then there's another, is this the same Bruce or a different Bruce?
I'm guessing it's the same Bruce, but let me double check. Same Bruce.
And then there's a Bruce blueprint in 97, correct? Is that the same Bruce or a
That is the
different
same
Bruce?
Bruce. That's all Bruce too.
Then there's the notation Greenman, and that was your husband?
Yes.
And you're describing how good things were between the two of you sexually?
Yes.
And then there's down here the discussion of size. There's not a huge difference in size? Correct?
Yes.
And then it's written, but I'm definitely longer and noticeably thicker, which she noticed when giving me a BJ, correct?
Right.
And those were discussions that you had with Mark Jensen.
Yes.
And then more discussions about BJs, correct?
Yes.
And then there's Kevin, and then Greenman, and then Daryl?
Yes.
And descriptions again of what was going on
Yes.
between you and them. And then Exhibit 157, there's Darren, and then Todd, and then Brett, and then Bruce. Is that the same Bruce or a different Bruce?
Probably the same.
And then you write Ken, and then it's written here, it says Kendall in Wichita. Did you tell Mr. Jensen about anybody named Kendall in Wichita?
I don't remember that.
Do you remember ever telling him Kendall in Wichita hung like a horse?
Would have had to have gotten that from a friend of mine.
I didn't hear you.
I would have had to gotten that information from a friend of mine, but I guess I did. I don't remember specifically telling him that.
Anyway, and then you go and looking through these documents, and there's extensive and exceedingly private, intimate details concerning each of your previous sexual acts of intercourse, correct?
Yes, yes.
And it's your testimony here today that you don't remember when this conversation occurred?
I remember conversations occurring when I worked at Abbott, and that was in 1999 and 2000. Other
And
than
did-
that, I don't recall any other conversations.
And did your memory of those other conversations all just disappear when you heard your husband say over the telephone, we didn't have that conversation in 1998?
Objection. She said she didn't remember any other conversations. She remembered conversations at Abbott in 99 and 2000.
The objection's overruled.
So what was the answer?
No.
Well, when your husband said, we never had that conversation in 1998, you didn't say anything in response to that, did you?
No, I didn't.
You didn't agree with him, did you?
I wasn't listening to him. I had friends over that day, and I was more interested in what was going on in my house.
Well, were you listening to him before the July 2007 hearing where you testified that you'd never had sexual relations with Mark Jensen between October and the time of Julie Jensen's death?
Objection. Listening to what?
Overruled.
Yes, I was listening to him.
And so at that point, you were able to get your testimony to somewhat correspond with your husband's expectations, right?
No,
And it wasn't, well, I'll strike the,
that's not what I was trying to do.
okay. But it wasn't until after you consulted with your attorney that you owned up to the fact that you in reality had sexual relations with Mark Jensen repeatedly between October of 1998 and up to and including the time after Julie Jensen's death, correct?
Up to and including after Julie Jensen's death?
Well, are you denying now that you had sexual relations with Mark Jensen after Julie Jensen's death?
Objection. She asked for a clarification of the question.
I'd request the question be read back. I thought it was pretty clear.
second to last question was, but it wasn't until after you consulted with your attorney that you owned up to the fact that you in reality had sexual relations with Mark Jensen repeatedly between October of 1998 and up to and including the time after Julie Jensen's death, correct?
Would that be a yes?
And it wasn't until after you'd been reminded of the penalties for perjury in this case that you finally acknowledged that, oh, that conversation about all these intimate details with Mark Jensen could have occurred in 1998 after all, correct?
No, I just know it's been 9 years, and if you've got something that tells me different, that's fine. I just don't remember it at this time.
I know it's been 9 years, but you know, most people can go through an entire lifetime without having a conversation like the one that's just been described here. Do you agree?
Objection.
I remember having this conversation. Our dates just differ.
Well, you understand
No
that.
grounds overruled.
You understand that date's a big deal here, correct?
Yes.
You understand that there's evidence in the record, that there is email, that there's internet searches in the record that would suggest that your husband looked up the name John Jacques Joseph on the computer in October of 1998.
Objection. It's not, this witness is laying a foundation to answer that question.
Overruled.
Do you understand the question?
No, could you repeat it?
I request the question be read back.
Question, you understand that there's evidence in the record that there is internet searches in the record that would suggest that your husband looked up the name John Jacques Joseph on the computer in October of 1998.
And it's irrelevant what this witness believes.
Overruled.
Yes, I know that.
And you knew that before you came in to testify in this case, didn't you?
Yes.
You knew that was a theory of the defense in this case, didn't you?
What was the theory of the defense?
The theory of the defense was that you'd never had this conversation with Mark Jensen in October of 1998. That was the theory of the defense, wasn't it?
Objection. That's a fact, not a theory of the defense.
The objection's overruled.
I guess I knew it.
And so it was an important issue for you. You knew this was an important issue before you took that witness stand, before you took an oath to tell the truth to this jury. You knew that this was an important issue about when that conversation occurred between you and Mark Jensen, didn't you?
I guess.
And you knew at the time that I asked you that question, you knew that that was an important issue, didn't you?
I guess.
And you testified that that conversation never occurred in 1998, didn't you?
Yes.
And it was only after you were reminded on the redirect examination, if you call this a redirect examination, it was only after you'd been reminded of the penalties for perjury that it occurred to you, maybe you'd better tell the truth.
The objection mischaracterizes the witness's testimony.
Overruled.
I'm not lying. I just don't remember if there's anything that proves your statement to the
You're not
questioning.
lying. I'm sorry.
Ma'am, you have to tell the truth, regardless of whether the district attorney has impeaching evidence.
Well, I am telling the truth.
Right.
I just...
Well, your last answer.
Oh, okay, I understand. I am telling the truth. I just don't remember it, and if you showed me something that reminded me, then I guess I would remember it.
Well, what's
But
your-
I remember a different time frame.
What you're concerned about is that I've got some evidence that would prove that you're lying, and then you could be charged with perjury. So now you want to tell the truth. Isn't that the case?
No, I'm not concerned with lying. I'm concerned with being accused of lying when it's not something I remember.
Now your recollection is that this conversation could have occurred in 1998.
I don't think it did, but it might have. Not the whole conversation.
Now you testified on cross-examination that this decision to marry Mark Freeman was just an impulsive thing, a result of your naivety, correct?
I think she said that was his divorce.
I was naive and foolish when I married him, and I was impulsive when I left him.
Objection's overruled.
Sorry.
So you were impulsive when you left him and you were naive when you married him.
Yeah, that was the word that came out of my mouth.
And you married him in September of 1998.
Yes.
And you met him 6 years earlier.
I think so, yes.
And he got divorced from his wife in 1996, correct?
One of the times, yes.
And you'd gone to Africa with him sometime before 1996?
Yes. That was his second divorce then, I guess.
So the first time you met Mark Greenman, he wasn't married to his first wife?
He was. And then he divorced her, and then they got married again, and then they got divorced. But I can't remember the dates that all happened.
And yet your decision to marry him was because you were naive.
Not naive, just foolish would be the better word.
There were also questions on cross-examination about Mark never telling you that he murdered Julie. He never did tell you that, did he?
No.
And you testified that if Mark had told you that he was planning to kill his wife back in 1998, you'd have dropped him like a rock, right?
Yes.
So Mark Jensen had a very good reason to withhold from you, a very good motive to withhold from you the fact that he was planning to murder his wife.
There's no fact here.
It's argumentative.
Well, if in fact, if Mr. Jensen was planning to murder his wife, he had a good motive to not tell you about that, right?
I suppose so.
Because you wouldn't want to marry a wife murderer, would you?
No.
And you wouldn't want to remain married to a man who murdered his first wife, would you?
No.
So Mark Jensen has a pretty strong motive. If he did murder his wife, Julie Jensen, he's got a pretty good motive to not admit that to you, doesn't he?
He does.
No further questions.
Recross.
Mrs. Jensen, at the hearing in July 2007, when asked about sexual relations, you acknowledged that you had sex with Mark Jensen in Appleton, Wisconsin, correct?
Yes.
That was truthful?
Yes.
You were asked other questions about sexual relations, and you had in mind sexual intercourse.
Yes.
Mr. Jamboy was asked additional questions about sexual relations, true?
Yes.
And he was getting more and more heated up as he was asking those questions, wasn't he?
Yes.
And it occurred to you that maybe he was using sexual relations in a broader sense.
Yes.
Fair to say?
Yes.
Did you testify before as a witness?
Never. Well, except for my divorce, maybe, if that counts.
And after you realized that he may be using the term sexual relations in a broader sense, you felt you ought to clarify that, right?
Yes.
Is it fair to say you didn't exactly know how to do that at the time?
Yes.
And as soon as you got off the witness stand at the first break, you asked your lawyer how to handle it, right?
Yes.
You had told your lawyer beforehand that you'd engaged in oral sex, correct?
Yes. Yes.
And you didn't go on that witness stand intending to deny oral sex if that question was asked, right?
Correct.
And no specific question about oral sex ever was asked by Mr. Jamboys, correct?
Yes.
And when you had the chance to come back on the witness stand, you explained that if sexual relations means something broader, then I have more to tell you, correct?
Yes.
And then you proceeded to tell them about every instance in which you had had oral sex, right?
Yes.
And there weren't any documents that showed that you had oral sex, right?
No.
There were emails.
Just the emails that alluded to them.
There were emails that alluded to an ongoing romantic and sexual relationship, correct?
Yes.
You knew about those emails beforehand?
Yes.
You knew the prosecutor had the emails beforehand?
Yes.
It wasn't like all of a sudden they pulled out the emails and you were surprised by them, right?
Right.
You had gone over the emails before you testified, right?
Yes.
You knew exactly what you'd be confronted with in terms of the emails, right?
Yes.
And if you had been asked the specific question of oral sex, you would have answered from the very first question that you'd had oral sex on several occasions with Mr. Jensen, right?
Yes.
You were asked, Mr. Jamboys, asked several times whether you had engaged in numerous acts of oral sex with Mr. Jensen. Do you recall that?
Yes.
And
Not oral sex.
of sexual relations
Okay.
in the fall of 1998, correct?
Yes.
Sexual relations including intercourse and oral sex.
Yes.
Just so I'm clear, Your Honor, are we talking about the hearing in 2007 or today's testimony?
In today's testimony, he was using the word numerous, correct?
Yes, yes.
And rather than using something vague like numerous, let's identify the times. There was in Appleton, correct?
Yes.
And prior to that, there was an occasion in St. Louis, is that right?
Yes.
There was this occasion in Chicago.
Yes.
Was there another occasion in St. Louis? Do you recall?
I don't recall.
The Appleton office opening was around October 1st, is that right?
Yes, I assume so. I don't remember the date.
And you knew the September occasion in which you performed oral sex on each other was earlier in September, correct?
Right.
And the middle to late part of September, you were with Mr. Greenman out of state, right?
Yes.
On your honeymoon?
Yes.
And then after Appleton, you were in Chicago, correct?
Yes.
And are those the only times you got together that you recall right now?
That I recall.
And if there was one more,
There may have been. I can't pin it down.
after Chicago, was there any occasion in which you had any kind of sexual relations until, through the end of the year?
No.
And the only time you saw Mr. Jensen in November was at that blueprint where you were attending with your husband?
Correct.
The only one I have is that one right there. That's the only one that I have of that match.
Here. This is.
Counsel, are you looking for this exhibit 165?
No, I'm looking for the base stamp, 234.
It's 234.
Oh, it is, oh, okay.
Are you gonna mark all of it?
It's all 166.
Yeah, so this is all the base stamps.
This is Jensen. Let me show you Exhibit 165 and Exhibit 166. Now, 165, is that a single page from a calendar or a daytimer kind of thing
Yes.
that has your husband's handwriting on it?
Yes, it does.
Does that contain the types of sexually explicit material regarding past relationships?
Yes.
And is there a date on that day timer page?
Yes, it does.
What's the date on that day timer page?
13 Tuesday, June 2000.
Would that be consistent with your recollection of the general time period in which these kind of conversations mostly took place?
Yes.
And then exhibit, I'm sorry, what's the one with the binder clip?
166.
166, and if you could just take a moment and glance through that for me, please. You've had a chance to glance through that,
Yes.
Mrs. Jensen. Some of the pages that make up that larger binder clipped exhibit are pages that were shown to you by Mr. Jamboys, is that correct?
That's correct.
Generally speaking, the subject matter of that exhibit is the sexually explicit notes of your past sexual relationships.
Yes.
There also are some internet chat transcripts contained therein.
Yes.
And do some of those chats deal with that same subject matter?
Yes.
When would those, is there a date on those internet chats?
I see a time, but I don't see a date.
When would those internet chats have taken place, if you recall?
It would have had to have been after April of '99 up until September of 2000.
And why do you say it would be in that time period?
It was the only time I had access to instant messaging. Or that I used it.
When you were at Stiefel Nicholas, did you ever use internet chat?
No.
Do you have specific recollection of having these kind of conversations regarding your past relationships while you were at Abbott?
Yes, I do.
Were those on the phone, by email, by internet chat?
Some were by chat, some were on the phone.
Did they also occur in person?
Yeah, I think we had some at home, yeah.
Do you recall having those conversations, let me just first of all ask, by phone, other than at Abbott?
I would say if we had the conversations by phone, they would have been like on cell phone when I was en route to or from the office.
Not while you were at work?
No.
And why is it that you recall that was during the time you were at Abbott?
I just have a recollection of being in a certain position where I had nothing else to do, so we had all that time, and he was asking very specific questions, and I was trying to remember everything, and it was an odd conversation.
Did you have a longer commute when you worked at Abbott than when you worked at Jockey or Southport Bank?
Yes.
Was that why you'd be more likely to engage in a cell phone conversation of some length?
Yes.
Now, you were asked whether any of these conversations could have taken place in 1998. right? You recall
Yes.
that? And are you able to rule that out or not?
I don't remember having them, but I'm not going to swear to it.
Can you remember the first time that this subject matter ever came up?
No.
Have you ever seen any emails that related to that subject matter while you were at Stiefel Nicholas?
I don't remember seeing any. What do you mean? Conversations?
And, well, we've seen a lot of emails in this case, correct?
Yes.
And those took place when you were at Stiefel Nicholas, is that right?
Yes.
And I'm just wondering, are there any emails that you've seen either presented in this case or elsewhere dealing with that topic of past sexual relations that were communicated in emails while you were at Stiefel?
Not that I recall, no.
Was there any time in the past when you recalled that such types of conversations did occur in 1998?
Did I recall? No.
I mean, is that something you thought at one time and now have dismissed, or is it just something you just feel you're not absolutely certain about?
I was pretty certain we only had the conversation at that one point in time, which went on for a while. I mean, it wasn't just one day. But
What point of time is that?
I've made a lot of comments and been proven wrong, so I'm not real sure of my memory anymore.
What point of time were you talking about?
When I was on the instant messaging.
99 and 2000.
Yes, 99 and 2000.
What? Yeah.
Your Honor, I have an objection about the line of question that's pertaining to Exhibit D167, and if counsel could show it to the court, you'll see why.
We're going to have to take a break here anyway, for 10 minutes. 10 minutes, and a quick smoke. You have an objection to 167?
Yes, I do. It's hearsay. It's self-serving hearsay. It's the defendant's communications with this witness, I forgot, was it December 2nd?
Yes.
Yeah.
Did you want to respond?
Judge, it's a statement of the of then existing mental impressions.
Well, I'm not sure I agree with that, but it does strike me as a statement of present intent.
Okay, which part of it does that mean? I don't get that.
I'm going to go get the boys and get them at karate, and I'm going to check on the woman and take them for hamburgers. And there is some part of it that is hearsay, I suppose.
It's all hearsay, Your Honor. If I'm introducing it, it's the same by a party opponent. If he's introducing it, it's hearsay.
No, there are parts of it that are not hearsay. Well, they're hearsay, but they're accepted under the rule.
You're talking about the present sense impression?
No.
Then which one? I thought this
No,
one you just
it's
said. Statement of plan?
statement of intent.
I need that statute.
The part about, oh boy, that was a scene, made me promise that I wouldn't call anyone and have her put into a rubber room like her mom and brother. That would be hearsay.
Judge, ultimately, I think this entire statement will be admissible under the rule of completeness. As the state introduces certain statements of Mr. Jensen, I think this also is relevant and admissible to show he appears to be at work, emailing at this particular time of day. And I would agree with the court in terms of his intent, and also his, I think his then existing emotional and mental condition regarding his view of his wife's situation.
Well, Your Honor, it's this.
You know, there's this cryptic entry. Wonder what kind of reality I'm going to be dealing with tonight, or how this resolves. Are you sure you want to offer this?
Yeah. I mean, if I put in the whole thing, I do. If I can't put in the whole thing, I don't.
Well, I would say that's probably admissible, as is going to go get the boys and get them to karate at 4 today. And then think we'll go home and check on the woman, probably something simple like burgers and cheese, etc. Going to have some explaining to them tonight. I suppose, again, that's admissible. Because it's not an assertion of historic fact.
It is a statement of fact. And, Your Honor, what is the
where-
portion,
no.
under what theory is it that you think that that portion is not hearsay? You said it was a,
Then existing subsection 3, 908.03, subsection 3, a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition, such as intent, plan, motive, design, mental feeling, pain, and bodily health. But then the one about what happened when he took the prescription, that's hearsay.
Judge, I'm inclined, if that's the court's ruling, I'm inclined to, I think this is later admissible under the rule of completeness, but we're not there now. I guess maybe if we could get I don't even want to say a stipulation, but if there aren't authentication type problems later on, or that I don't have to have her identify these as her words type of thing, and have the court decide an issue of completeness later on.
Are you agreed that if the court ultimately decides that the entire message the entire train, is that what they call it, the train?
I don't know. The string of emails?
String, whatever it is, that if I ultimately decide that it can all come in, are you going to have any objection to its being received without a sponsor at that time?
You mean without this witness testifying?
Any sponsor.
I won't object to it unless, I don't think it's ever going to come in unless I offer it. But if it ever does come in over my objection, I'm not going to doubt or question its authenticity. I'm not going to say that that was an email between some other people.
Are you going to dispute its lack of a sponsor at that time?
No.
Okay. Does that do the trick?
It does, and it just so we don't have an issue with the jury, I am going to ask Mrs. Jensen if they had email correspondence on December 2nd in the afternoon, and she may need to refresh her recollection with this document, but I won't ask about the content.
I think it's irrelevant, so I'll object to that. It's irrelevant what they had email communication. If he's not going to ask about it, what difference does it make with that email communication on December 2nd, 3rd, or 4th?
The fact that he may have had internet or email conversation with her that afternoon would be admissible without reference to the.
And that it was she received an email from him at work on that afternoon of December 2nd. Yeah.
At her work.
Yeah, from his work.
From his work email address.
Right.
Okay. Okay, that shouldn't be a problem. Now you have 3 minutes. The court reporter has.
The prosecutors, and it's difficult for me to remember precise questions, but certainly the word perjury, I think, was mentioned on a number of occasions, and the court's admonition to the witness to tell the truth when I think she was doing her level best to tell the truth and explain the circumstances behind her testimony. I believe all that, I believe the combination of those things has unfairly prejudiced Mr. Jensen and undermined his right to a fair trial. And I also move for mistrial on those grounds, in addition to the admission of all the evidence regarding these sexual relationships.
Well, let me ask you, did you feel that a reasonable person could not have had the concern that I had after she made the answer that she made?
I did not see it at all the way the court did.
I didn't say you agreed with me. Do you think the conclusion or the risk that I thought existed from her answer was an unreasonable interpretation?
I did not think, I guess, you know, in all honesty, Judge, I did not think that was reasonable, but my greater concern is...
No. Unreasonable. Did you think that a reasonable person could not have had the concern that I had based upon the answer which he had given?
A reasonable person could not have had?
The concern that I had based upon the answer which he had given.
Yes, a reasonable person could not have had that.
Okay, let's hear it again. I thought she said something to the effect that suggested to me that she was saying that if the district attorney has evidence which could show that she was not telling the truth, that she'd answer in a certain way.
No, what I thought the witness was trying to explain is she really was timid about making a mistake, and it's a long time ago. Her only memory is 99 and 2000. You know, but if you know, could it be 98? Well, I
Well, I don't
guess
want to get into, you're getting sidetracked. I want to hear what, I guess we'll have to find what was said, and maybe I was in error. But the point where I interrupted and instructed her that she had to answer truthfully regardless of whether the district attorney had contrary evidence.
That was quite a while ago, wasn't it?
Well, it could take a while. It'll take a while for her to do that. I need some water, so.
It won't take her a while, it'll take her a short time.
Yeah, it's a good idea to answer that. Can I get some? Be right back. Hurry. Right after the order.
Apparently it was just before recross, probably.
Okay.
Okay. Can you read back the question that the DA asked? Her response?
Well, don't go on the record, because then it's going to go back to...
Okay.
The question was, and it was only after you reminded on the redirect examination, if you call this a redirect examination, it was only after you'd been reminded of the penalties for perjury that it occurred to you, maybe you better tell the truth. Then there was an objection. The answer, I'm not lying, I just don't remember if there's anything that proves your statement to the question, you're not lying. And the court said, ma'am, you have to tell the truth regardless of whether the district attorney has impeaching evidence.
Read her response once again.
The answer was, I'm not lying, I just don't remember if there's anything that proves your statement to you're not lying.
I took that as suggesting, I took her response as suggesting that she said, I'm not lying. I just don't remember if there's anything to prove the assertion that the district attorney is making. And I took that to mean I'm not lying, and I don't remember if there's anything that's going to entrap me. And I'm not saying that's the only reasonable interpretation, but I think it is a reasonable one, and one that it's part of my job to guard against.
I guess I understand, I guess, a little better what the court is saying, and that was helpful to have it read back. My concern is, I think that she was fumbling to articulate her position. And like the court said, I think there might be several reasonable possibilities there. My belief is she was fumbling to articulate that she might have some memory issues and just didn't want to make a misstatement. And my concern is that the court's admonition makes it seem like the court has an opinion about the truthfulness of her testimony.
Your objections noted, and I think I've stated the reasons I made the statement that I did, and I think it was appropriate, and I think it was, if indeed the interpretation is that she was making what would have justified my concern, then I think I would have been delinquent in my duties not to have made the admonition. So I make no apologies for it, and your motion is denied. Anything else?
Yes.
What?
Well, Your Honor, previously on my redirect examination of the witness, it had been my intention to ask her about a question that was posed to her on page 26. There was an objection to it, but nonetheless it was asked, and I'll read it now. Page 26, line 13. Actually, I need to read the question preceding that. Line 8. Question, and it's your testimony that notwithstanding those email communications, notwithstanding that you only had sexual relations with him one time in the beginning of October 1998. Answer, yes. Question, now I will ask you to remember something, ma'am. You are under oath. And the fact that you've been offered use immunity does not excuse you from being required to provide under penalty truthful testimony during the hearing. And there was an objection, and you indicated that that's been done. Now, on the recross of this witness, Mr. Albee was once again leading this witness through this and indicating, oh, well, she was just inexperienced and she was confused about my questions regarding sexual relations, and she didn't realize that that included cunnilingus and fellatio. And, you know, he's entitled to do that, but in the process of, but then I'm entitled to go back and point out to the jury, point out to this witness in the front of the jury, that in fact she was reminded of perjury back then too. And she was reminded that she was required to testify truthfully. And it was after that reminder on the record that I made, in her presence, there was a break, and when she came back, it was after consulting with the attorney that she then testified truthfully about the previous sexual relations. Now, you had sustained the objection before, and my guess is you would not sustain the objection now.
Well, as a matter of fact, I agree with you. And I looked at this as he was reading, and we were trying to tiptoe through it, but I do think for the purposes for which it's being offered today, it would be admissible.
But he's already asked that 10 or 12 times probably. He asked the question, he said, you only told the truth last time after I reminded you of the penalties of perjury. He's asked that here. He didn't read it here, but he asked that. And
well, his point is a good one. I think you did cover that. You had admonished her at the time of the hearing in July about the penalty of perjury.
I did. And you know what, Your Honor? Then when he was attempting to rehabilitate this witness on his recross examination, he went through this again. He was clearly trying to implant in the jury's mind the notion that, oh, she's a novice witness. She just, and maybe doesn't know that much about, you know, what sexual relations the term includes, whether it includes cunnilingus and fellatio or not. You know, it's implausible when you consider.
She's already. I believe you asked her on your redirect whether she was admonished about the penalties of perjury, and she acknowledged that she had been. And so I don't think we need to go through this again, even though he did. And if you want to make the argument, you're welcome to do so. And I do think that, so the record is clear. All the business we had come in this afternoon about the salacious business, about the fetishes or whatever it is all related to John Jacques Joseph, and it's not a minor matter. It is a major issue in the case. So, anything else?
No, Your Honor.
No.
So I'm not going to be permitted to ask that question.
No, sir.
Okay.
Ask the jurors to come in, please.
Judge, you have
Last one.
Please be seated.
We've got to stop taking these long breaks. Go ahead, whoever's next.
That would be me, Judge. Thanks. Mrs. Jensen, you have in front of you an exhibit. I think it's exhibit number 167. Is that right?
Yes.
And using that exhibit to refresh your recollection, do you recall whether you received any emails from Mr. Jensen on the afternoon of December 2nd, 1998?
Yes, I did.
And did you respond to the emails on December 2nd, 1998?
Yes.
From the email, where is it that Mr. Jensen sent you an email from?
It says Jensen Mark Racine. That would be the office. His office.
And what time did he send you emails at?
Let's see. Looks like around the 3 o'clock time period, between like 3 and 3:30. From what I can see, I can't see all the times. Oh, there's one at 12:30. Nope, that was from me.
Does it look like there's, starting with page 2, is there an email at 2:54?
Yes.
Then moving to page 1, and then additional emails at 3:04, 3:13, and 3:22 p.m.?
Yes.
And those were sent from his work to your work?
Yes.
That's all I have.
Mr. Jensen?
Mrs. Jensen, during the course of your relationship with Mr. Jensen, has there been a time when you've been deathly ill, sick, and barely able to get out of bed?
Objection. Relevance.
It's not hitting me right between the eyes.
Well, there was just a discussion about an email communication between between the defendant and this witness that occurred on Wednesday, December 2nd, a time when there's been testimony when Mrs. Jensen was deathly ill and Julie Jensen was deathly ill and sick and barely get out of
There's
bed.
actually been no such testimony.
Well, if there hasn't been, there will be.
Pardon me?
If there hasn't been, there will be.
I'm still not understanding the relevance of this question about this witness.
Okay, the next question would be then, if you were sick and deathly ill and barely get out of bed and barely able to breathe and barely conscious.
Just a minute.
I wasn't finished making my reference.
Write it out. Write out the rest of it. I heard as much as I want to hear out loud. Just write out the rest of it.
Okay. Now, Mrs. Jensen, it's your testimony on the cross-examination that the reason that you didn't initially disclose the numerous sexual encounters that occurred between you and Mark Jensen between October of 1998 and time leading up to the death of Julie Jensen is because you had some misunderstanding of the meaning of the word sexual relations.
Yes.
But you do recall that I admonished you at that time on the record about the potential penalties for perjury?
Objection. This has gone over before.
Oral.
Yes.
And it was after that there was a break, correct?
Yes.
And it was after
Well,
consultation.
this was gone over on your redirect.
So did that influence your decision to come forward, or was it simply because you were mistaken about the meaning of the word sexual relations?
I was mistaken about the phrase, and then when I spoke with my attorney, he explained to me he didn't explain to me anything. He just said, you need to make that clear on the stand.
No further questions.
Any questions?
No.
You may step down.
Your Honor, at this point, the state would request the opportunity to play the video of the Jensen residence that was taken on the evening of December 3rd.
Any objection?
No objection. I don't believe it's been admitted into evidence, but I also don't object to it being admitted into evidence.
That
It
was
just
received.
should be, yeah.